They come down all from 10 years to 90 days.
That was, again, there was no people.
It don't matter, it's the law. No, it's the law. It's the law, though. They gotta follow the law.
You will find that for that.
It's the law.
But he's deciding about the insurance. I'm gonna write down those closing. We already got some there. The closing is the last one, you know, every time. Before they start. So here is the instructions. It tells them what their bond is. Then we do closing. These notes still leave out some of the stuff about your. Yeah, because then it's
And that one guy said something, get her ass up here.
they can think about it on their own. They didn't break for what to do. Yeah, they didn't know what to make it. I don't know how much we can work on it. We already bought it.
Say something in that too. Never comes from the office. You don't have to have much discussion.
He's running the papers.
No matter. He did it last time, too. I'm not even ready to go fucking about it, you know? Yeah, and that. That was like one point five of it. You know, so
We will record and hand it to you.
it don't matter.
I can look at it.
That's what
I don't
happened.
do it.
That's what
One day more people charge
It
it.
don't matter, it's the law.
Things down just to not have to look as hard. Which is, it's a tax. It's a good thing that the struggle is going to be good for us. Because the right will fight even harder. It's been a struggle. It won't be just if you give us Absolutely.
For real, I ain't worried about it. I'm not going to do it.
We have to bring people that are actually, bring people to action. Nobody that works at the jail wants to lose their job. Nobody's trying to bring their license.
Okay. Comments on each other's sets of instructions?
Hey, can I say something, y'all? How about a conflict of interest in the case?
Should let your attorneys know.
Talk to your attorney, and we'll make the argument for you if you wish.
Judge, in answer to the court's inquiry about instructions, Commonwealth's tendered instruction makes no mention of the gun made of cardboard, which is one of the items they have introduced it into evidence, and it is part of the indictment, so I guess at this point, we're hoping Congress and see if that doesn't qualify as dangerous contraband. Would ask then for the second degree promotion. That's going to qualify for that.
The only thing we were interested in is the first degree, promoting contraband, and I'm willing for them just to consider, what is into evidence. The 1, 2, I guess that is, but of anything, if they consider any of that to be dangerous contraband, find them guilty. If they find none of that to be dangerous contraband, just find them not guilty. I wasn't interested in a second degree promoting instruction.
I think that just one needs to be found in order to meet the requirements of promoting contraband. However, I think the defendant is correct as far as for review of the case by a higher court. I think we do need to have the jury tell us which one they are finding is dangerous contraband. So your instructions on each piece about whether it's dangerous contraband or just contraband, I think are something that the court wants to provide to the jury. And I think also, I assume that you are wanting the instruction on the lesser included of promoting contraband second degree.
Yeah.
Obviously, since you've tendered one, and it's the court's obligation to produce that in case in case the jury does determine that none of this was dangerous contraband, then that's where it would go. And we do need to get the rulings on that. Otherwise, most of the instructions of the Commonwealth I prefer. I think that, but I think we do need to make some, we will need verdict forms giving them the choice between first degree and second degree. I want the verdicts forms also specifying each item the way the defendant has presented it, determining whether it's contraband or dangerous contraband. Because some of it they may find was dangerous and some of it they may find was not. But it only takes one. And I think that should probably be also explicitly in the instructions that it only takes one instance of dangerous contraband to be promoting contraband in the first degree. So we'll take a recess and I'll ask the parties to work on those things. In other words, I think that the jury needs to be instructed that only one item of dangerous contraband is enough to meet the requirements of promoting first degree, and also giving the option of second degree if they find that none of these items are dangerous contraband. And also I will want special verdict forms for each item, whether it's dangerous or non-dangerous. Okay? All right. So let's just take a recess at this time and just let me know when you're ready with that. Okay, thanks. Okay, we need to fix that. Okay.
That is not, I don't know where that came from. I don't know where that came from. We didn't know that.
See if it's still in there first, see if it is.
It's money. Here it is. Something about this insurance. Supposed to go check in with Heather, but I don't know.
It does need to say more.
We're not ready.
Have a seat, we'll talk about these a little bit.
Okay.
If I check in with Heather.
Go ahead. Right. Okay, on instruction 1, I think since we're going to have a specific instruction on each of the items, that on that one, that could, okay, I've crossed out, starting with consisting of a length of rope, I crossed through until I got to finished with and a sharpened shank made of metal. In other words, the listing of the things. And it just says, defendantly, knowingly made, obtained, or possessed dangerous contraband while confined in the Harlan County Detention Center.
Okay.
Which is the elements. And then, since we're going to ask specifically for each one, whether it was contraband or dangerous contraband. Okay. Then the same thing with count 1, instruction 2. It says dangerous contraband. I crossed out dangerous and I crossed out the same thing, consisting of a length of rope and so forth. Let's see now. Right. Okay, then the definitions I think are okay.
The only request we've got is under instruction, where it talks about if one item of contraband is determined by the jury, that needs to be a unanimous determination. So I don't know where you want to put the word unanimous.
Right. Okay.
If it's unanimously determined by the jury.
I think that's fine. That's
All 12 of them agree that it is.
yeah. Is unanimously determined?
Yes.
Unanimously determined. Agreed with one item.
Okay, good.
Donor, in the second degree instruction, you cut out the listing of the items as well, is that
Yes.
correct?
I did also the word dangerous.
Dangerous.
Other than that, Judge, I don't think we have any objections.
Okay.
Obviously, other than this, we, nothing to get first.
Other than giving any instructions at all, right?
Other than that,
these are really
I was going to say live, but I read it for real. There's no something I like to listen to. I don't know where I'm just getting them on the day. I'm not going to get out of it. Yes, I was saying, I really, how do I get
Because that's the fun company that is
I'm very flexible. Both sides. Okay, is there anything else? You want to fax this over to Lisa or something? We have the fax.
I don't know the case. I don't know.
Her email, wasn't one of her emails, she just, judged me.
Cell phone.
I've actually done that.
We don't know what my text message.
They were emailed here, so I mean, they're in here. If we could make, they're here, if we can make changes to it.
Okay.
Yeah, so that's just be on Heather's computer. I mean, I'd be glad to walk up there and say,
Yeah, when you can.
Rant, just right here, we rant in the road, and rant the color up. Cover my camera. And I come out with the camera, right? You can find it, a lot of things. Mr. Hurd, except for my text message. Working to get from him. I think it takes
That's lovely.
I know. I don't know what to do. Keep one.
I'm not gonna make some shoes and stuff. I take some out there. Lord, what do you mean give me my loan? What are you talking about giving me my loan? I said, you know, say the phone is what it costs you, you know what I'm saying?
Let me look through it first.
They did it, they flooded the community one time. The TV's kind of small, the TV has to go right in that corner.
They wouldn't really
Yeah, the dummy had to wait
Who you talk to on the phone? Legal part? Where's it at?
2 years later, probation style.
You got your computer with you? You got it. Be damn. I got it. Right on it. I couldn't move Luke, well, you got that? Look through everything's on the back. As a matter of fact, it's on the, is it on the back of that? Contraband. Yeah. So, there's a name and number, because these are, he's always done my cases.
It's got it, Judge.
Any suggested improvements or objections or anything of that nature from either party? Okay. The jury will be back in here in a few minutes. Some had asked to go smoke. And that was almost 10 minutes ago. So I told them to go smoke a cigarette and come back into the courtroom. Because we don't want cranky jurors. Out, and that will be the one who has been the alternate.
Barbara Creech.
Number 48. You're excused. Yes, we had 13. One was an alternate because sometimes things happen during trials where we lose a juror for some reason. And that way we don't have to declare a mistrial and start over again. So before they return, the jury returns to the jury room to deliberate, we select one by randomly, and that was the one who was the, it's kind of like going to the party but not being allowed to dance, but
So I can leave.
yes, you're excused. You can leave. Thank you for your service. Okay. Okay. The Commonwealth and the defendant has announced closed with their case. At this time, we've been working on the instructions. At this time, I will read the instructions to you, and then you can retire and deliberate. After closing arguments, you can retire and deliberate on your verdict in the case. When you retire, feel free to go through the instructions again. You will be given a copy. It will be laid on the table in the jury room. First thing is to select a foreperson, then go through the instructions, and then deliberate. Now, I'm going to read the instructions. Some of the instructions at the end are things that you need to know for the verdict forms at the beginning. So listen to make sure you pay attention to all of them. Instruction number 1, first degree promoting contraband. You will find the defendant guilty of first degree promoting contraband if and only if you believe from the evidence beyond a reasonable doubt that in this county, on or about the 17th day of October 2013, and before the finding of the indictment herein, the defendant knowingly made, obtained, or possessed dangerous contraband while confined in the Harlan County Detention Center. Instruction 2, definitions. Knowingly. A person acts knowingly with respect to conduct or to a circumstance when he is aware that his conduct is of that nature or that the circumstance exists. Dangerous contraband means contraband which is capable of such use as may endanger the safety or security of a detention facility or persons therein, including but not limited to dangerous instruments as defined herein, and saws, files, or similar metal cutting instruments. Dangerous instrument means any instrument, including parts of the human body, when a serious physical injury is a direct result of the use of that part of the human body, article, or substance which, under the circumstances in which it is used, attempted to be used, or threatened to be used, is readily capable of causing death or serious physical injury. Detention facility means any building or premises used for the confinement of a person. A, charged with or convicted of an offense, or B, alleged or found to be delinquent, or C, held for extradition as a material witness, or D, otherwise confined pursuant to an order of court for law enforcement purposes. Instruction 3, reasonable doubt and presumption of innocence. The law presumes a defendant to be innocent of a crime, and the indictment shall not be considered as evidence or as having any weight against him. You shall not define the defendant not guilty unless you are satisfied from the evidence alone and beyond a reasonable doubt that he is guilty. If upon the whole case you have a reasonable doubt that he is guilty, you shall find him not guilty. Instruction 4, unanimous verdict. The verdict of the jury must be in writing, must be unanimous, and must be signed by one of you as foreperson. You may use one of the forms provided at the end of these instructions for writing your verdict. Instruction 5, if even one item of contraband is unanimously determined by the jury to be dangerous, the element of the crime of promoting contraband in the first degree concerning dangerous contraband has been met. Jury verdict. Form 1, first degree promoting contraband. We, the jury, find the defendant Shelby L. Shell not guilty under count 1 of first degree promoting contraband. This the blank day of March, which would be today, 2014, and a line for the foreperson. Or, we, the jury, find the defendant Shelby L. Shell guilty under count 1 of first degree promoting contraband. Place for the date and the signature of the foreperson. Verdict Form 1A. We, the jury, find the rope alleged to have been located in the confinement cell of the Harlan County Detention Center assigned to Shelby L. Shell, Jr. to be contraband or dangerous contraband. And there are places for you to check one or the other. Place for the foreperson to sign in the date. Verdict Form 1B, we, the jury, find the fake knife alleged to have been located in the confinement cell of the Harlan County Detention Center assigned to Shelby L. Shell, Jr. to be contraband or dangerous contraband. One or the other. Verdict Form 1C, we, the jury, find the paper gun alleged to have been located in the confinement cell of the Harlan County Detention Center assigned to Shelby L. Shell, Jr. to be contraband or dangerous contraband. The date and the foreperson. Verdict Form 1D, we, the jury, find the sharpened metal piece alleged to have been located in the confinement cell of the Harlan County Detention Center assigned to Shelby L. Shell, Jr. to be contraband or dangerous contraband. And you choose one, and today's date, and then the foreperson. Instruction 6, second degree promoting contraband. If you do not find the defendant guilty under instruction number 1, you will find the defendant guilty of second degree promoting contraband under this instruction if and only if you believe from the evidence beyond a reasonable doubt that in this county, on or about the 17th day of October 2013, and within 12 months before the finding of the indictment herein, the defendant knowingly made, obtained, or possessed contraband, not dangerous contraband, contraband, while confined in the Harlan County Detention Center. Jury's verdict form, second degree promoting contraband. We, the jury, find the defendant Shelby L. Shell not guilty under count 1, instruction 1 of second degree promoting contraband. I'm going to cross part of that out. Which is the count. It's not that. It's the instruction of second degree. We, the jury, find the defendant Shelby L. Shell not guilty under instruction 1 of second degree promoting contraband. We, the jury, find the defendant Shelby L. Shell guilty under instruction 2 of second degree promoting contraband. That should actually be in instruction 6, so I'm going to make that alteration. Sorry I didn't catch that before. Are you in agreement? The Commonwealth may give its closing argument. No, I'm sorry, the defense first. The defense gives their closing argument. I was doing openings.
Yes. Thank you, the court. Come on. Ladies and gentlemen, as you can guess, we're done. This is the closing arguments. The defense didn't have any witnesses. We didn't produce any witnesses. But again, we didn't need to. We don't have the burden in this case. The burden is all on the Commonwealth. They have to prove Shelby Shell's guilt beyond a reasonable doubt. That's their burden. It's not ours. So Shelby Shell didn't take a stand and testify on how he disapproved. That's not on us. You have to prove.
Excuse me, Mr. Solomon.
Yeah, can you hear me?
In looking through the instructions, we had an instruction tendered which did not make it into the final draft that we all looked at, and that do you have a set of the proposed instructions to the last revision? Approach with the ones you have, please. We didn't have the right to remain silent instruction on the ones that I've had.
We didn't have what?
Right to remain silent. Right not to testify.
It
It was in the earlier versions,
Yes.
not in the last one.
We'd have no objection to the court adding that, reading it after closing arguments. If or now, whichever the court.
I'll just read it and allow him to start. He's only,
Yeah.
Mr. Settleman's just
That's
part way in. Does somebody have a copy of it?
I don't have any.
I should have one.
This is from the defendant. We'll use it if we have to, but I like theirs better. I can't. Oh, here we are. Thank you. Okay, this is it.
Your Honor, we attended those to the court, presumption of innocence and all that, and the court has those. We didn't go.
Right, we did the presumption of innocence.
Yeah, it was right.
But I thought after we did the revisions, I thought I gave you back. We have it now. Okay. There's an additional instruction. I'm going to allow Mr. Seidelman to start again. There's an additional instruction, which was in the earlier versions that didn't make it through, but it is one of the instructions for the jury. It's instruction number 7, right to remain silent. Every citizen charged with a crime has the right to remain silent at trial. This is because it is not the citizen's responsibility to prove that he is innocent of any crime. The law presumes a defendant to be innocent of a crime, and the indictment should not be considered as evidence or having any weight against him. A defendant is not compelled to testify, and the fact that the defendant did not testify in this case cannot be used as an inference of guilt and should not prejudice him in any way. That's all right. Now,
Again, knows what the judge just read will happen when we go back in the jury room to read again and go over. But as I was saying, the doubts in this case come down to 2 elements. What does it mean that there's no video of Mr. Shell actually committing crimes? And did the jail staff actually search Mr. Shell's cell before he went in? I think all the doubts come from that. There's no video. You know, I'm not gonna stand up here and say that this is one of those movies with Jerry Cop where he goes around and unplugs the camera. I don't think this is wrongdoing, but it's possible. But jail staff, I believe, Officer Moore testified that there was a search and there's just no recording. Okay. Well, if we had a video, we could see what they claim to be true, which I've got my doubts, that he climbed 15 blocks up a wall and tore down a piece of metal within the span of a few hours, and then took that metal and shaved it on the concrete and made it sharp, and hit it all in the span of a few hours, all without anybody seeing it, anybody hearing it. I think you would have heard testimony today if it did exist, that somebody watched it on the television live, because I don't think that's something that you could do in the span of 2 hours, in the span of 8 hours. However long it took for them to notice or say there was some suspicious activity in the shower, I think it would have been long. And I think if we had that videotape, we could see it or not see it. But we don't. We don't have it. We can bet. I think we can all agree that if they did have the tape, you would have seen it. You know, but they don't have it. It doesn't exist, and we don't know. So we're left with doubts. Now, as to the cell being searched beforehand, you did hear it was Lieutenant Howard say, "Oh yeah, of course we searched it." And you heard Derek Moore say, "Yeah, we control what goes in and out." He said they're not allowed to have spoons. Well, clearly, Shelby had more than one spoon. They can't give a spoon and keep track of one individual spoon. I'm not sure that they're doing what they say they're doing. And I don't think it's wrongdoing. I call it complacency. I think when your video feed doesn't work for 5 years and you don't get it replaced, you don't get it. You think, well, this is your facility. We know what goes in and out. We know what's going on. I think they don't need it and they don't pay attention to it. They certainly don't document when they search the cells. We didn't see any paperwork about that. We didn't have any search forms, any results. That was clean. Nobody signed off on it. And I think more telling, there was no video of an initial search. So maybe there was a power search during that initial search too, but there was no video of that either. So I understand that people might have gone out during this specific time period. It's a little bit questionable to me that the video of all the previous searches, which if they had, would convince you all beyond a reasonable doubt that they actually searched it. I mean, I think we would all be convinced if we had something. But we don't have anything. We don't have anything that shows, besides Lieutenant Howard saying, "Oh yeah, we searched it." Just like Lieutenant Moore says, "Oh yeah, they don't get spoons. They don't get them." But they do. Somehow it happens. And I know I talked about civil cases, criminal cases. In civil cases, you've heard doctors getting sued for opening up the wrong leg or for leaving behind particles, even though they track what goes in and they track after surgery. They do the best they can. Mistakes happen. Okay? It happens. It does. And it happened in this case. In this case, Shelby was given a cell. In that cell, underneath the toilet rim, there was a sharp metal object. Shelby didn't know it. He didn't use it. He certainly didn't show it around. He didn't do it. So Shelby didn't create that. I think if you believe their story that he actually climbed the walls, pulled off a piece of metal, and sharpened it, there would have been other evidence. There would have been cuts on his hands. That metal is not easy to work. When Officer Moore put on gloves, I thought he was going to show us maybe some fingerprints or some DNA. There wasn't any of that. I'm not saying there needs to be, but there's not. And it's just, there's nothing really there. There's no scratch marks on the floor. There's no evidence that he sharpened it. Whereas there would have been. Now, clearly somebody climbed out and took it, right? It exists. It's in the cell. But they don't have any proof that Shelby did it. They don't have any proof that Shelby was the one that did it. Now, as to the gun and the fake knife, okay, they're toys. It's what people do. They play with stuff. They make art. They create things. They're in a cell 24 hours a day. You're going to come up with something to do. Shelby made some stuff together. As far as the rope, I guess you could call it dangerous, but it was just in his shoe. It's another piece of clothing. It's a belt. Oh, his pants up. He uses ropes to bind down his discovery. He doesn't use rope as a weapon. It's a dangerous weapon. He was out in the open. Officer, I don't know his name, but he testified that it wasn't even concealed. Same as with the gun, the toy gun, and the shiny toy knife made out of a spoon. Those weren't concealed. The only thing that was concealed was underneath the rim of the toilet that Shelby didn't do. And I think if you look at all that evidence, you will have doubts, and you will have doubts. And I say beyond a reasonable doubt. I've said that a lot. I kind of want to give a demonstration here to show you exactly what I mean about that. The law has a lot of different legal standards. This is just a
Counsel?
No.
I'll have to object to that. I mean, he cannot in any way attempt to define reasonable doubt.
Do enough to stop your car.
I'm not trying to define it, I'm trying to define what it's not. I think by saying what the other standards are and that this is higher, I'm not trying to define reasonable doubt at all.
There is enough to take your child,
I mean, that's just true.
enough to arrest,
I mean, I think these are all just facts under the law.
enough to stop your car.
But I think the fact that those are things leading up to, no, I'm not going to allow that.
I will say, there's case law that says, beyond all doubt is not beyond reasonable doubt. And I think these are clear elements of these things, enough to stop your car. But not
Reasonableness,
enough to take your liberty.
that assumes so
And I
many
think we can-
facts, not in evidence.
No, you can't do that.
Okay. Well, can I say it?
No,
I can't say that clear and convincing is enough to take your child.
no,
No.
because I think
And I
that
can't
comes
say
to,
that reasonable doubt is the highest standard.
the trouble is that we are prohibited from making any attempt to define reasonable doubt.
And I'm not necessarily defining it, I'm just saying what it's not, and that's
Yeah,
just
no,
fact.
you're defining the things that lead up to it, and I wish we'd had a motion in limine on this, but with the majority, we don't, and so I just have to do the best that I can with it. I think it's too close to making an attempt to define reasonable doubt. Okay. Reason, I think,
Determine a picture of the evidence. Not the whole thing, but just a picture of it, or a copy.
Just to preserve the record, would it be okay if we took a picture of it and add it to the record?
yeah, we can definitely put it in as a proffered or tendered exhibit during the closing
Okay.
argument. Yeah.
So
We preserve
I'm
the
putting
record.
that on the record that we want to take a picture of this
Right,
and
absolutely,
add it.
you can do that.
Over there.
Yes. You can even use the, yeah.
Sorry about that. There's some issues with the law. I was going to try to maybe define what reasonable doubt is, but that's not necessarily my job. That's your job as a juror. Can't really tell you what that definition is. I wanted to get a clearer picture. I can tell you that it's the highest standard of the law, and that your job as a juror is to tell if they've actually met that burden of proof, which is beyond a reasonable doubt. And the reason it's so important, of course, is because of man's liberty to stay. So I would ask you to look at the evidence, look at the evidence that's missing, and if you have just a doubt, it says in the jury instructions, a reasonable doubt, you have to come up with a verdict of not guilty. And thank you for your time, and thank you for serving.
Thank you, Judge. Mr. Simon? Well, we just heard a lot about there is no video. So let's think about what is there. Let's take a look at it. We'll take all the evidence back, but I'll just ask you to think about these two things. Now, what the defendant's been charged with, what we ask you to find him guilty of is promoting contraband in the first degree. The definitions, the instructions you'll take back with you say, if a defendant makes, or if he even obtains, or if he even possesses dangerous contraband, he's guilty of promoting contraband in the first degree. So, we have established these people, these employees from the detention center testified, they search a cell before they put somebody who's going to live in the cell by themselves. They search the cell to make sure it's clear before they ever put him in there. He lived in there for 2 months by himself. No other inmate ever had access to that cell. Now, the defense seems to be saying, because we don't have some video of him making these things, I mean, do you really think for 1 minute that Shelby Shell would just sit out in the open and say, I think I'll work on this today out in the open, and I know there'll be recording in it all, I know they'll be observing. Of course not. Derek Moore testified that at least 85% of the shower area is not even subject to surveillance. There is some privacy. What was the complaint that led to the search? He's in the shower area for a long time. So they decided to search, and thank goodness they did. That's a question that you have to answer. You're going to have to answer specifically about each item. First of all, I mean, you'll get to look at this and you'll get to observe this. That is some very careful work. And you're going to have to determine, this is contraband, if it's dangerous contraband. You have to ask yourself, could this be dangerous for an inmate to possess? He did not have it laid out. It was in his shoe. He didn't know he was going to be searched that day. But could this much rope easily be looped around your neck and strangle you? How many seconds would that take? And then add this in. Does this look like, and really do observe it, if you want an inmate to have this, would this be dangerous in the hands of an inmate if it's plunged into the neck of a guard or anybody else? So that's really all that there is to consider. No, there's not any video, but these things were found. And this putty, and it's secured underneath the toilet rim. The piece was broken off. And he says, well, there's no evidence that Shelby Shell could climb up there and break that off. Well, there is the sworn testimony of the employees of the detention center. What evidence is there to contradict what they said? They searched these cells. The safety of their own cells, the safety of all inmates is at stake. They searched the cell before they put somebody, an inmate like Shelby Shell, into a cell to live alone. And in secret, somehow, both of these things turned up. Thank goodness they searched when they did. That's what you have to determine. If he possessed these things, did he obtain them? Did he just possess them? Either way, if you consider these to be dangerous contraband, he's guilty of promoting contraband in the first degree. We ask you to find him guilty of that.
Mr. Bailey, please check the jury room and make sure that there's nothing in there relating to the trial that can have an improper influence on the jury. Could you raise your right hand and be sworn? Do you swear and affirm that as a bailiff in the charge of the Harlan County Circuit Court, of the jury of the Harlan County Circuit Court, you shall not allow any communications to be made to the jury under your charge, nor make any yourself, except to ask them if they have agreed upon their verdict, unless by order of the court? And do you further swear and affirm that you will not, before their verdict is rendered, communicate to any person the state of their deliberations or the verdict agreed upon? Okay, thank you. When you take them back, lay this on the table. Members of the jury, if you would follow the bailiff to the jury room for your deliberation, and let us know when you've reached a verdict.
All rise.
Judge,
Yes, wait.
evidence.
Oh, we have evidence to be taken back? Do we have another bailiff take this back for us? Thank you. There's this, is that all of it? Okay. Those exhibits go back with them. Okay.
All rise.
Seated. Okay, I count 12 jurors in the box. You have selected a foreperson, is that correct? And have you reached a verdict? Okay, could you hand that to the bailiff, please? Thank you. I'll read the verdict. Jury's verdict, Form 1, first degree promoting contraband. We, the jury, find the defendant Shelby L. Shell guilty under count 1 of first degree promoting contraband. Verdict, Form 1A. We, the jury, find the rope alleged to have been located in the confinement cell of the Harlan County Detention Center assigned to Shelby L. Shell Jr. to be dangerous contraband. Verdict, Form 1B. We, the jury, find the fake knife alleged to have been located in the confinement cell of the Harlan County Detention Center assigned to Shelby L. Shell Jr. to be contraband. Verdict Form 1C. We, the jury, find the paper gun alleged to have been located in the confinement cell of the Harlan County Detention Center assigned to Shelby L. Shell Jr. to be contraband. Verdict Form 1D. We, the jury, find the sharpened metal piece alleged to have been located in the confinement cell of the Harlan County Detention Center assigned to Shelby L. Shell Jr. to be dangerous contraband. And they're signed by the foreperson. Would counsel like to examine the verdict form?
Oh, yeah.
Okay, thank you. All right. Now, having found the defendant guilty of promoting contraband in the first degree, there's a second phase, the sentencing phase, in which the jury will determine the punishment, the length of time. So if you'll return to the jury room for right now, we will need to go over some discussions concerning instructions on that phase, and then we'll come in and commence that. It will be shorter than the trial you've already had. So thank you. If you'll just go back with the bailiff to the jury room.
All rise.
Let's see now. Be seated. Okay, I had some instructions already. Did you have instructions to tender on that phase? Okay, let me see those.
And Mr. Gibbs looked at him, right?
Yes.
Okay, I have I've taken the instructions you have and modified them a little bit. I've taken out the count 1 reference. Since we're at this point on the sentencing phase, they're not, I took count 1 references out of the other instructions too, because although we have a PFO charge, they're not to know that at this stage. But, here, come up and, the council come up and take a look at those. Let me know if I've left anything out. Oh, wait a second. Yeah, that's right.
Right, 1 to 5.
Oh, well, the second degree needs to come out.
Right, there is no second degree this time, right?
I'm sorry?
There's a
There's-
second degree, penalty phase instruction, second degree promoting. That just needs to
No,
be.
we don't need that.
1 to 5. And that's the second degree. The only thing I had included, so these are fine right here. That's just the basic. But don't we need a right to remain silent and unanimous verdict?
Right.
And
Yeah.
those were in my packet. Here's that second degree. No, I just stuck on that.
Yeah.
I will put this panel on really quick. I'll offer sentencing guidelines. So offer it. So
Good.
then I'll pop her on and say, when are you for all those quantities?
Unanimous verdict, right to remain silent. First degree.
Offering that certified
Take a look at those then and see if that's got.
Unanimous verdict, right to remain silent, promoting and promote first degree.
Yeah.
Okay.
There's no one's number here. I guess that would be, and there's the verdict. This is an instruction, so I guess that needs to be 2.
That's why they have
That says instruction 5.
So that really needs to be.
Yes, sure, yeah.
So you
Just
can,
want to mark them.
you want me to write it?
Yes, I trust you.
As long as you're watching, all right.
That's right.
No, one's face all down. 1, 2, 3.
Okay.
And then verdict form is the last page.
Yep. And Judge, are you combining your truth in sentencing and PFO phase, or do you bifurcate?
It's actually trifurcation, I guess.
Trifurcate.
Yeah, we do separate phases. But this should be fairly quick. What, do you wish to do opening and closings? Do you want to just do closings, or, okay? And what do you have as far as evidence that,
I'm just gonna offer the certified copy of the sentencing guidelines, put Jenny Powers on for, you know.
We'll have a few follow-up questions and
Flat to say,
then we're
what are
done.
you, all I'm gonna ask is, what are your paroles wanna do?
right, that sounds fine. Already. Get the jury back in now.
I kept my shoes on, that's my, every time I had my shoes on. I've got my front back, my shoes were really bad for the front. Listen, I'm doing this,
All rise.
Be seated. Okay, we're now at the penalty phase. The counsel for each side has waived an opening statement, so we'll proceed directly to proof for the Commonwealth.
I'm sorry.
Everybody present your proof.
Okay. First of all, Judge, I would like to offer into evidence, I consulted with the defense, a certified copy of the certification on the calculation of parole eligibility from the Kentucky Department of Corrections. I will offer that. I'll ask the clerk to mark it.
Is there any objection?
No objection.
Okay, that's submitted into evidence. It's exhibit. Is it 7 or 6? Okay.
And other than that, I'd just like to briefly call to testify Jenny Powers.
You raise your right hand, please, and be sworn. Do you swear or solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Okay, thank you. Have a seat.
Would you please state your name for the record?
My name's Jenny Powers.
And how are you employed?
I work for the probation and parole as an investigator.
How long have you been employed by probation and parole?
2 years.
Now, in the course of your duties at probation and parole, are you familiar with the guidelines to be able to, for example, tell this jury, given the kind of crime that the defendant's been convicted of, when he will be parole eligible?
Yes.
Okay. Would you like to see this Commonwealth's Exhibit number 6, which is the calculation sheet of parole eligibility?
Yes, please.
Okay. First of all, this charge that he's been convicted of, promoting contraband in the first degree, is that a Class D felony?
Yes.
Okay, so according to the Department of Correction guidelines, when will Mr. Shelby be eligible for parole? First of all, let's talk about the range for a Class D felony. To the best of your knowledge, is that 1 to 5 years?
Yes.
Okay, and how much of his sentence, whether it's 1 year up to the 5 years, how much of the sentence will he have to serve before he's eligible to be considered for parole?
If it's a Class D, he has to serve 15%.
Okay, so there's no guarantee he'll get it, but he will, after 15% of whatever sentence he's given, then he can be considered to be paroled, correct?
Correct.
Okay, that's all. Thank you.
Thank you. Ross?
Ma'am, just a couple of quick follow-up questions. When someone meets the parole board, there is, as I think prosecutors asked you, there is no guarantee they'll be paroled the first time.
Right.
They could be told to come back in 6 months or a year, what's referred to as a deferment. Is that right?
Yes.
And they could also be served at. And what is this served at? Do you know?
They would have to serve all their time.
Okay, so they'd have to serve the sentence.
Yes.
And when someone is paroled, are they released to the supervision of the Department of Corrections Parole Division?
Yes.
And when they're on parole, they are supervised,
Yes.
drug tested?
Yes.
They have to maintain employment where possible?
Yes.
Got to maintain an active and current address, if that's correct?
Yes.
So they're not just allowed to go free once they're released on parole.
Right.
That's all the questions I have.
Okay, anything else? Okay. Would the defense like to, do you have any evidence to present?
No, no.
Would you like to proceed to a closing argument?
Yeah, sure.
Okay, go right. Here we go. Testify. Thank you, you're excused.
Thank you, Your Honor. Please report to the Commonwealth. Ladies and gentlemen, part of the trial that you're doing now is equally as important as the first part. Where you've been asked the first part of the day to look back, we now ask you to look forward. You have a sentencing opportunity here from 1 to 5 years. You will decide, very minimum, how much time Mr. Shell will be incarcerated before he's eligible to be released. In addition to that, you also know there are other factors. His record, what happens to him on paroles, he's going to be monitored and supervised. He's going to be drug tested. He's going to have to maintain contact with the Department of Corrections. I'm not going to ask you for a specific amount of time. I'm just going to ask you to look forward and return a reasoned verdict for the amount of time you think Mr. Shell should receive for what you did.
Okay. Thank you. Commonwealth?
I think I'll ask you to do the same thing. To give a reasoned verdict considering what we have here. It's a Class D felony, penalty range 1 to 5 years, and now you know, whatever you give, 15% of that time he'll be eligible for parole. 5 years, be eligible for parole in about 9 months. But what I ask you to consider is, remember the testimony you heard about these things that an inmate has in the jail, and they were described as lethal, potentially deadly. So there are different types of contraband and all, and I think that your sentence, the sentence you impose, should really go along with what kind of contraband was this person in possession of, or what kind of contraband did this person create. Just let the sentence go along with the level of danger that you see and just the seriousness of that offense. Thank you.
Okay. I'm going to read you the instructions now. It is now your duty to determine the punishment to be imposed upon the defendant. You may consider evidence presented to you during the first phase of the trial as well as evidence presented to you during the second phase in your deliberations. If you find the defendant you have found the defendant guilty, it says you will fix the defendant's punishment at confinement in the penitentiary for an indeterminate sentence, the maximum term of which will be fixed by you at not less than 1 year, no more than 5 years, in your discretion. Instruction 2. The right to remain silent. Every citizen charged with a crime has the right to remain silent at trial, including the sentencing hearing. This is because it is not the citizen's responsibility to prove that he is innocent of any crime. The law presumes a defendant to be innocent of a crime, and the indictment should not be considered as evidence or as having any weight against him. The defendant is not required to testify in this phase, as is his right. You shall not draw any inference of the appropriate punishment from his choice. You shall not allow his choice to prejudice him in any way. The verdict of the jury must be in writing, must be unanimous, and must be signed by one of you as foreperson. You may use one of the forms provided at the end of these instructions for writing your verdict. We, the jury, fix the defendant's punishment at confinement in the penitentiary for blank years, not less than 1 year, no more than 5 years. The date, place for the foreperson to sign. These can be given to the foreperson, and you may escort the jury to the jury. Thank you.
All rise.
Oh, and here's an exhibit to go. Thank you. Court will remain in session, but will not be doing anything until the jury returns. You can leave if you wish. jurors have returned. Foreperson, have you reached a verdict? Submit that to the court. Okay. We, the jury, fix the defendant's punishment at confinement in the penitentiary for 5 years. This 4th day of March 2014. Would you like to inspect the verdict? Okay.
No.
All right. Counsel, approach the bench. Okay. These are the Commonwealth's tendered instructions. Okay. So you've looked at them.
Yes.
They're fine to me too, so thank you. Do you intend to introduce any evidence in this phase? Obviously you will for the PFO.
Just, I'll put a certified copy of the prior convictions that are the basis for the PFO. And then I just thought I needed just to very briefly again put on Jenny Powers to show when his parole ended, to establish not more than 5 years had expired since his parole was completed on those charges. So very briefly.
That's
Okay. Do you want opening statements or closing arguments?
certified copy.
No, I guess if you just now read count 2 and then go right into that, that's fine with me.
That's fine, Judge.
Okay, I'll do it. There was a count 2 of the indictment, which by law we were not allowed to disclose to the jury until they'd reached the phase they have now. And that count 2 is that the grand jury further charges that the defendant is a persistent felony offender in the 2nd degree, to wit, that previous to the date of the offense charged in the indictment herein, the defendant, who was more than 21 years of age at the time of said offense, had been previously convicted in the Harlan Circuit Court in Harlan, Kentucky, a court of general criminal jurisdiction, and was sentenced on the 9th day of January 2004 for indictment number 02-CR-00224 and/or 02-CR-00226 and/or 02-CR-00240 for a term of imprisonment of 1 year or more for felony offenses committed when the defendant was more than 18 years old. Further, at the time of the offense contained in the indictment herein, the defendant was still on parole or probation for said indictment, or less than 5 years had elapsed since the completion of the defendant's sentence, parole, or probation for said indictment, and the defendant's sentences for the above indictments were not served currently, nor were they served consecutively, that's concurrently, nor consecutively without interruption, contrary to the provisions of K.R.S. 532.080 and against the peace and dignity of the Commonwealth of Kentucky. Okay, that was the 2nd count. The counsel for each side has waived an opening statement, so we'll proceed to the proof of the Commonwealth on this point.
Thank you, Judge. I'd like to offer into evidence, I have 3 certified copies of the prior convictions of Mr. Shelby Shell. The first certified copy is in case number 02-CR-224, which found the defendant guilty of criminal mischief 1st degree, theft by unlawful taking over $300, burglary 3rd degree. A certified copy of the conviction in 02-CR-226, in which the defendant was found guilty of burglary 1st degree, burglary 3rd degree. And finally, a certified copy of the conviction in 02-240, finding the defendant guilty of robbery 1st degree. So I will offer these certified copies as a collective exhibit. And I guess that's Commonwealth's Exhibit 7.
Is there any objection?
No objection.
All right.
Other than that, Judge, I need to briefly recall Ms. Jenny Powers.
Ms. Powers, you're still under oath. Just be seated.
Ms. Powers, we just introduced into evidence the previous certified convictions of Mr. Shelby Shell. Are you familiar with those?
Yes.
Are you familiar with the amount of time that Mr. Shell was required to serve under those previous convictions?
I believe so. I believe he had a 10-year.
Okay, 10 years. Okay, and the entry date of those convictions, do you recall if that was in January of 2004?
Yes.
Okay, so now the question that I have for you is, from the 10-year sentence, and this was combined together, correct? Those three cases that I read off, combined together, total of 10
Yes.
years?
Yes.
Okay, now, did you do some research at the request of the Commonwealth and determine when either Mr. Shell's prison sentence was complete or when his parole was complete from those previous convictions?
Yes.
Okay, and what was that date?
That date was May the 1st, 2013.
Okay, May 1st, 2013. His parole ended?
Yes.
Okay, all right, that's all. Thank you.
Any cross-examination?
No.
Okay, any evidence on behalf of the defendant?
No.
Okay. I will read the instructions for this phase. Instruction number 1, second-degree persistent felony offender. You will find the defendant guilty of being a second-degree persistent felony offender under this instruction if and only if you believe from the evidence beyond a reasonable doubt all of the following. That prior to October 17, 2013, the defendant was convicted of criminal mischief first degree, theft by unlawful taking or disposition, and third-degree burglary in criminal action number 02 CR 224. First-degree burglary and third-degree burglary in criminal action number 02 CR 226, and first-degree robbery in criminal action number 02 CR 240, all by final judgment of the Harlan Circuit Court on January 9, 2004. B, that he was 18 years of age or older when he committed the offense for which he was so convicted. C, that pursuant to said prior conviction, he was sentenced to a term of imprisonment of 1 year or more. D, that he completed the service of the sentence imposed on him pursuant to said prior conviction no more than 5 years before October 17, 2013, or 2, that he was discharged from parole or probation from the sentence imposed on him pursuant to said prior conviction no more than 5 years before October 17, 2013, or 3, that he was on probation, parole, conditional discharge, conditional release, or furlough or appeal bond from said prior conviction at the time he committed the offense of which you found him guilty in this case, or the time he committed the offense of which you found him guilty in this case, he was in custody for said prior conviction, or 5, that at the time he committed the offense of which you found him guilty in this case, he had escaped from custody while serving a sentence for prior conviction, and that he is now 21 years of age or older. Instruction number 2, presumption of innocence. As you were instructed in the first stage of this trial proceeding, the law presumes a defendant to be innocent of a crime, and the indictment shall not be considered as evidence or as having any weight against him. The same is true with respect to the persistent felony offender charge described in instruction number 1. You shall find the defendant not guilty of being a second-degree persistent felony offender unless you are satisfied from the evidence alone and beyond a reasonable doubt that he is guilty. If upon the whole case you have a reasonable doubt that he is guilty of being a persistent felony offender, you shall find him not guilty. Court's instruction to the jury, instruction 3, the right to remain silent. Every citizen charged with a crime has the right to remain silent at trial. This is because it is not the citizen's responsibility to prove that he is innocent of any crime. The defendant is not required to testify in this phase, as is his right. You shall not draw any inference of the appropriate punishment from his choice. You shall not allow his choice to prejudice him in any way. A defendant is not compelled to testify, and the fact that the defendant did not testify in this should not prejudice him in any way. Jury verdict form. Second-degree persistent felony offender. We, the jury, find the defendant, Shelby L. Shell, not guilty under count 2 of being a persistent felony offender. Or, we, the jury, find the defendant, Shelby L. Shell, guilty and fix his punishment in lieu of that fixed under instruction number blank, I'll have to fill that in, at no less than 5 years nor more than 10 years under count 2 of being a second-degree persistent felony offender. Okay, these two, penalty phase, count 2, instruction 1. If you find the defendant Shelby L. Shell guilty of being a second-degree persistent felony offender under count 2 of this indictment, you shall state in your verdict, and in lieu of the punishment you have fixed for the defendant under instruction number blank, you shall fix his punishment under this instruction for promoting contraband in the blank degree under count 2 of the indictment at confinement in the penitentiary for a period of not less than 5 years, no more than 10 years in your discretion. be the, here we go. Defense, would you care to give a closing argument?
Yes, Your Honor. Again, may it please the court. Ladies and gentlemen, we are at the end of a long day. I certainly appreciate your patience and attention. As the judge told you, there are some things we can't tell you until a certain point in the trial. That's obviously what this is. Persistent felony offender gives you the opportunity to decide what sentence you want Mr. Shelby to have. You've already determined a 5-year sentence. The question is, do you wish to increase it? 6, 6.5, 7, 8, 9, any combination therein. If you look at the previous sentencing guidelines, you will see that parole eligibility is now moved up to 20%. Again, the same conditions apply before. When he's paroled, he's going to be monitored and supervised. You don't have to increase the sentence if you choose not to, but you can. The question is what to do. Well, obviously, we're here with Mr. Shell today because problems in the jail he's had. Obviously, found him guilty. Equally obviously, decided a 5-year sentence was imposed. Again, looking forward, what else do you want to do? One additional time? Or are you satisfied with the 5 years you have? That's all entirely up to you. I'm going to sit down now and trust you with perhaps the most important decision you'll make today, Mr. Shelby. Again, we appreciate everything you've done. Appreciate your service. I have an opportunity to talk to 5th grade classes in the spring every year because they study government. They get tested. And I tell them, without jurors, we trial lawyers. So I appreciate it. Thank you so much.
For the Commonwealth.
I agree with that. Thank you for your services. This is the first time I've seen every one of your faces, every time a jury's called up, and you serve, and you do so faithfully, and so patiently, so truly. I mean, we are grateful for that. I just want to make sure that you understand, when you have to determine, first of all, is he a PFO, persistent felony offender? Yes, he is. If you look at that, the date of his conviction, that'll go back with you. It was in 2004, but it was a 10-year sentence. And so that's why Ms. Powers testified that his parole ended in May of 2013. If you pick up another felony within 5 years after you either serve out or your parole ends, you're a persistent felony offender. You step up. The 1 to 5 crime becomes a 5 to 10 crime. Now, Mr. Gibbs is saying you don't have to increase the sentence. I mean, you can step up from 5 in the 1 to 5 to 5 in the 5 to 10, but that is your decision. And I think you spoke loud and clear about the seriousness of the type of dangerous contraband that Mr. Shell had. But now, I think what you have to consider, take a look at these previous convictions. We have certified copies of them, and you determine now, with the felony history, and now another felony while he's incarcerated, what is the appropriate term between the 5 and the 10 years. You have to pick a sentence between there, and I certainly do trust your judgment.
now retire and deliberate on your verdict.
All rise.
All right, be seated. The jury find the defendant Shelby L. Shell guilty of second-degree persistent felony offender and fix his punishment in lieu of that fixed under instruction number 1 at 10 years under count 2 of being a second-degree persistent felony offender. The council may examine the verdict if they wish. Is there anything else to take up?
No, Your Honor.
Okay. Members of the jury, you're excused. Thank you for your service. I know it's been a long day, and you've had a lot to get into because we had 3 phases of the trial, but thank you for your service. And you're free to go. And call the answering machine Wednesday evening after 5. No, I'm sorry, Thursday evening after 5. We may have a trial on Friday. So check on Thursday evening after 5.
There's nothing much to add.
Okay, be seated. The court will set sentencing for April 17th. Is it-
Your Honor, is there any way that we can move that up? Is March 20th reasonable?
The 20th.
I have a lot of faith in Ms.
Is that
Powers.
reasonable? Can you prepare the pre-sentence investigative report in that time? March 20th is what they're asking for.
I'll have to look and see how many I actually have on that day. And that might be, I'm short notice, but I can try.
I think there are a few from February 20th that were scheduled for sentencing that were bumped to that date, but I don't think there are a whole lot that are new.
I also have London that I'm doing as well.
Yeah.
You have what?
I'm also doing PSIs for London. Getting
Okay.
ready to get some PSIs from London who gets their short. So I haven't been signed up yet, but
Just a moment. I'll set it for April 3rd. That's in between the 20th and the 17th of April, so we'll set it for sentencing on April 3rd and ask that the PSI report be prepared by the end of the day on the 2nd, April 2nd. And we did get we did get a response from probation and parole as far as giving the pre-sentence investigative report to counsel. And that is, I can do that. I can order that be done, and I'm going to order that. Now, it will be under some terms of confidentiality and things of that nature, but you will be receiving those in advance of the sentencing. The Commonwealth will now. Okay. Is there anything else to take up today?
What time on the 3rd do you want to start?
You can be here at, we can make it later than 9. How about 10? Give you a little extra time to get here?
That'd be fine. I
Okay.
appreciate it.
We'll do that. 10 a.m. on April 3rd. Okay, anything else? Okay, the defendant's remanded into custody to await sentencing. And to be held at the Harlan County Detention Center awaiting that. Of course, he has another charge that's being held there on too, so.